right, so why don't we get started? So my name is Adam Traidman. I'm the general manager of ChipEstimate.com. It's part of Cadence. And today I'm going to be the moderator for our panel on global markets and IP reuse. I'm going to be addressing some of the business, legal, technical issues around IP reuse from a kind of a global perspective. So I'm joined today by a great set of panelists that we have here. We've got Gerd here from GlobalFoundries. He's a director of design enablement. He's based in Dresden, Germany. We've got a long history with AMD and Motorola, and he'll have some great perspectives for us. As GlobalFoundries, as you may or may not know, is a company that is quite global in nature, spanning a bunch of different countries and a bunch of different activities around the world. We also have Coady with us. Alan is a senior director of engineering at IDT. IDT is a fabless semiconductor company, also with a lot of global operations, a lot of different product lines, and really great IP reuse methodology. They're a leader in IP reuse, and so Alan will be sharing some of his insights with us as well. And then third, we have Jonathan Kaplan. Jonathan's a little bit more unique to the DAC audience. Jonathan's actually a lawyer, so no tomatoes or anything like that. He's from the law offices of Jonathan Kaplan. And he's going to join us with some interesting insights into the legal aspects of semiconductor IP reuse. So in terms of the format for the panel today, I'm going to kick things off with just kind of some general comments and some context setting on the overall IP market globally. Then we're going to allow each of the panelists to kind of give a statement, kind of tell you a little bit where they're coming from in terms of their perspective on things. And then we'll immediately move into questions. And I really hope that you're planning on participating today. We certainly won't have time for questions from everybody. But please start thinking of what you want to ask now so that when we do move to the questions, we can have something interesting there and keep it interactive. So I've got some statistics, just kind of talk about the IP marketplace in general to kick things off. So Gartner is telling us that in 2011, we're looking at about just under a $2 billion market for semiconductor IP worldwide, across design and verification IP. It's been growing really fast. And for those of you who've been in the industry for a number of years, you've probably seen a lot of trends and a lot of changes in the area of semiconductor IP. And I've got some kind of interesting statistics on this. We went back into the ChipEstimate.com database, where there's a lot of aggregate data on chip estimations. And then we also went and collected some data from some other reports as well. And I put together this statistic that looks at like the average percentage of a die that is reused IP. So the average percentage of the die area on a chip, any given chip that is IP that was reused from prior generations or was reused on multiple chips. So about a decade ago or so, that number was at about 19%. Okay? And if you look at the data from last year, it's jumped all the way up to 78%. So clearly, a huge change, huge acceleration in the reuse of IP. And I think we're seeing that reuse across pretty much all sizes of semiconductor companies, right? I mean, the IP reuse value proposition, it makes sense in a small, maybe a small startup or something like that, right? Because you might not have internal to the organization the engineering experience and some interface that you need to put on the chip or something of that sort, and you go out, you find a trusted quality supplier, you bring that IP in, probably cheaper than it would cost you to build it, and a heck of a lot faster because it's probably already done. So the value proposition there is pretty strong. It just sort of makes sense. Even in larger companies now, larger semiconductor companies, maybe like where Alan joins us from, these companies used to be a little bit more vertically integrated, and even in the largest ones, companies like Intel and IBM, these historically very vertically integrated companies, we're starting to see an acceleration of reuse as well. It's kind of like the trend that we saw in EDA about 20 years ago, when companies like Cadence and Synopsys were forming, right? They were competing essentially with internal EDA tools, CAD organizations, and big companies like IBM. And ultimately what happened is these semiconductor companies outsourced that to the EDA industry. That's what created this, right? Everything that we have here around us today. And now we're seeing that same trend in the large companies in the area of IP. So especially in these standard interface kinds of IP where you can check that an IP conforms to a spec, and that gives you the confidence, right, that it's going to meet your needs. We're seeing a lot of divestment of that internal IP creation for those standard interfaces and other like kind of star IPs, right, like processors and whatnot, and a lot more sourcing. And what I think that says is that the IP industry has matured now to the point where they're trusted, they're generating good quality product, right? And the EDA companies and designers have the tools and the methodologies they need to basically do a good job of integrating and verifying that IP. All right, so now with that context, let me turn it over to each of the panelists. We're going to get started with my friend Gerd here and go through and set your context. Tell us a little bit about your thoughts.
Okay, so IP really and IP integrity, let's call it integrity, is based around trust. So you want to trust that your IP, which you're using, is number one, it works. Number two, it comes in time. And number three, it doesn't jeopardize your business. Because if it's from a questionable source, I mean, it can upset your business entirely. So especially if you look at the leading edge, there is one major problem on leading edge. And this is not IP integrity in this sense, but the number one priority for leading edge is time to market. So you want time to market, and of course linked to time to market is quality. So if your quality is not good, it blows your schedule. So you need partners who are reliable, who you are trustworthy, who can deliver the IP in time to quality. So in these cases, I think in the leading edge, there is less of an IP problem. Where we encounter this is in the mainstream type IP. That's where we start to see this.
Oh, your mic.
Oh, my mic is.
It's back now.
It's back. Okay. So so it's really in the mid range, and that's where the IP integrity starts to become a real issue, and where we need to focus on. Now there is a ripple through effect. So. It's going to be very hard for companies just coming in with like MP3 stealings type things. You download something and you sell it illegally, right. And this is not something you can easily do because there is a history to it. If companies start in the leading edge, ripple it down, it's less of a problem. But in the mid range there is some gray zone which I think we need to watch, and that's. Where I think is the focus of today's discussion.
Okay, thank you, Gerd. Alan?
Okay. Can everyone hear me? Okay, so so I see the engagement model for IP reuse in sort of three camps. One would be the most obvious, IP off the shelf. So the IP is mature, it's been proven, it's been used, and you go and get it. So that's the least risky, the most deterministic in schedule and quality and those type of things. But then there's also an engagement where you're picking up IP where it is midstream, it's new technologies or new capabilities, and you want to pick that up and be in the forefront. And that's obviously, really where you'd like to be a lot of the times. So that you start to have other risks and other considerations. And then a third engagement model might be that you outsource some IP development. So you want to own it. It's an expertise you might not have, or you don't have enough resources to go do it, so you want to outsource it, but you may want to own it at the end, or you may actually want to seed the development of it and pay a portion of it, not the whole amount, so you'll be the lead customer, if you will, right? But then you're defining it, you're part of the requirements and things like this. So there's a few different, and there's the three big ones. So in looking at that, they each have their own challenges, obviously their own benefits, and I sort of put them into two camps. One is an engineering camp or an execution camp, and the other is a business or a legal camp. And you have to look at these and be, on your game on both of these, because either one of them will burn you. So obviously off the shelf is easier from an engineering execution, but probably easier from a legal point of view, but you still have things for off the shelf like infringement, right? You still have maturity. Because it's off the shelf doesn't mean it's really good. It might be good in the sense that it's been in many devices. Perhaps your device is going to utilize it differently. So maybe those other devices had a lot of trouble utilizing it. They got over that. It's good now. But you put it in yours, and it's a different system, a different context, and you run into problems. So the off the shelf is, perhaps conceptually the easiest, but it's not risk-free, right? And for infringement, escrow, indemnification, things like that, you still have to consider those. They don't disappear. Then you move down to your midstream. So they're doing it on spec, but you're engaging early on. You might not have much say in the requirements, but you still want to be the first customer out there, or the group of the first. So then now you're concerned about their execution. You know, you're still concerned about everything you were off the shelf, but now you're concerned about other things. So now you have to understand the company a bit more. You have to understand the quality of the engineers. You might want to engage weekly in things like this, or whatever it needs to be. And then you move to the next one, where you want to, you want to contract out the development of IP. So that one is just an exaggerated one of the previous, exaggerated version. In there, now you're really interested in the company. You're really interested in the quality of engineers. You're probably meeting quite a bit. The requirements, you specifically want to drive them in certain ways. So you run into a set of problems that I find unique or more troublesome when you're talking with emerging countries, and that is the way we communicate. So the way we communicate in North America, we have some built-in stuff that we maybe don't realize, but I've dealt with IP companies in India and China, and the assumptions we make aren't the assumptions they make. So we fill in gaps for what we don't say. They don't fill them in the same way or fill them in at all, so you have to be very specific, right? And they want specific directions, and if you tell them to do the wrong thing, they'll do it very happily, and there you go. So there's another level of concern. Also, people in China and India, they don't stay at companies as long as on average in North America. So where you run into the problem there is, okay, depending on the model, you got to, sorry?
People move over.
Yeah. So think of it in every category. Depending on the model, you're banking on them getting it done on time, and now the same team that you started with at the beginning isn't the team you finish with at the end. That didn't help time to market, didn't have quality. Also, if you're speccing some IP for you to own, you signed an NDA, but what does an NDA mean? Like, the NDA is with the company, and obviously it can indirectly get back, or can get back to the people, but in practicality, you don't sign contracts to do anything with them other than please behave, right? Because if you're going to have to actually enforce a contract, you're going to spend more money than you ever did in this whole engagement type of stuff. So there's practical issues with that aspect. The maturity of the team, obviously. So there's some really good people in India, but there's a lot of people that are very good, but very junior, right? So I won't use that up any more time, but these are the things that I see are considerations.
Excellent. Thank you, Alan.
Okay.
Jonathan.
Thank you, Adam. Well, I'll just jump in now with some legal perspective, which will be a bit different. I'm gonna focus here on China and India. Actually, many business authorities advocate taking a joint strategy of China and India. It's not China or India. So that's something I think.
That's interesting.
Yes. And also I think that the better view is that you don't really go there to save money. You go there because it's part of a long-term strategic strategy. But these are emerging markets because they're undergoing rapid economic and industrial development. So from a legal point of view, there are basically three stages of a law. And one is what they call the promulgation of the law, which is when it's originally passed, but all you have is something on the books. The second stage, you have what's called the institutionalization of the law, which is when the country creates institutions and they actually enforce it. And then, and third, finally, if everything goes well in institutionalization, then you'll have what's called internalization, where basically the law will be essentially self-enforcing, and it'll be voluntary compliance. Everyone knows what it is, everyone thinks it's okay, or they know how to live with it, and people just follow it without needing enforcement. So basically, the emerging market countries, and certainly China and India, are in what you would call the institutionalization stage, which is the most critical stage of legal development. So I think the question is, with these emerging market countries, are they going to make it through that critical institutionalization stage? And key things there are the enforcement needs to be consistent, it needs to be transparent, and it needs to be seen as procedurally fair. And these are all things that both countries are working on. So there are interesting comparisons and contrasts, similarities and contrasts between the two countries. Basically, one is an authoritarian, coming from authoritarian roots. Basically, the other is essentially a democracy, but they both have this strange dichotomy where there's a certain level of what I'll just call, what they call lawlessness, basically. And that's because of the enforcement issue. So you have these strange dichotomies in these countries, and there are lots of other issues I could go on, but I think I'll just stop for now.
Lawlessness. That's an interesting term, actually, that you use. So I'm actually curious if anyone in the audience has any kind of practical experience, whether it's a success story or a horror story, involving something related to, IP from an infringement or a theft perspective internationally. Raise your hand if you've had some experience in that area, or if you have a question related to that for our panelists. No horror stories out there? Because you hear a lot about it, right? You hear that big IP companies don't want to do business in these emerging markets because they're afraid of the GDS being copied or the RTL being, on the streets of Shenzhen or whatever, on CDs, very much like many of the EDA tools actually are. I guess that the licensing from a technical perspective too around the IP is a little bit more difficult, right? At least with the software and the EDA tools, there's mechanisms in place to do that, right? But for the silicon, you almost have to pull back the package and try to scan the chip to see if your IP actually appears somewhere. So it'd be quite challenging. All right, so why don't we open up to the audience for questions just in a general sense then. We've got a microphone that's going to be floating around.
And Adam,
yes.
Complimentary of ChipEstimate.com, we actually have Starbucks cards for questions, so maybe that'll motivate it as well. So,
I have a question. Can I have one?
Panelists are exempt.
Okay. Lord knows we all need more caffeine, right, Ron? All right.
Hi. This question is really for Jonathan. So I'm with, my name's Keo, I'm with GlobalFoundries. So one of the questions I have is, what do you see the responsibilities of the foundries in helping enforce some of these IP infringements, and what are things that the industry can do to help facilitate that?
Okay, that's a great question. Well, I think there's a lot that foundries can do, particularly because I think in that case it's a relatively simple situation because companies like GlobalFoundries, which are large companies, they have the resources to enforce the IP rights. I mean that's your whenever you're advising a client whether you even get IP rights in the first place, there's always what I call the deep pockets problem. Do you have are you really going to be able to afford to enforce it because it's very, very expensive, right, as Alan alluded to. So one of the common ways to deal with that is to use arbitration as opposed to the court system. Particularly in China, they have an arbitration commission which is called CTAC, which is very friendly to foreigners. You can conduct the proceedings in English. You can have foreigners on the panel that decides the case and so forth. So I guess just to briefly reply to your question, I'd probably recommend arbitration in general, and and I think that larger companies, larger foundries can certainly enforce it.
It kind of leads me to another thought as well, Jonathan. So if, for instance, IP's been stolen or infringed upon, or for whatever reason there's an issue with some part of a design that our friends at the foundry are manufacturing in volume, does that put them at any material legal risk?
Well, it does. I mean, yes. I mean, the foundry is producing IP, even unknowingly. Certainly, there can be patent infringement. Does not depend at all on knowing that you're infringing, and with other forms of IP like trade secrets, copyright, you can still be at risk. Yes.
Yeah, in principle, we are agnostic to design IP as a foundry, so to speak, that our customers are making the deals with the IP companies.
Right, right.
However, there is some borderline. So like things like memory, things like non-volatile, like fuses, or things like I/O, ESD, and so forth. So this is relatively technology specific, and this is not something you can buy on the market easily. And this is something where we have to provide some help as well. And that's where we touch IP very closely then. So and we have to make sure that this is open and free to use for our customers.
Right, right. But you must have considerable concerns about that IP.
Yeah, but obviously for us it's bad if our customer has a problem here because he bought bad IP and he cannot sell his product. We will not sell wafers.
Right.
So we're linked here.
Yeah,
we're in with our customers.
Right. Gives you some reason to get involved in that.
Sure.
Okay. How about another question from the audience?
Thank you. I've talked to a few folks about this, CEOs and whatnot, and one of the things they'll say is, I'll say, well, you're going to have your IP stolen, or you're going to have, whatever it is stolen, and they'll say, yes, we will. So it'll be our architecture then that's stolen, and that goes around the country, and it'll give us a base for future use. So they recognize it and they say it's going to happen, but it may have some benefits. Any comments?
So I've heard it said by more than one company, they don't care. Basically, by the time it's stolen and by the time other people are using it, they're moving on. So I see two types of companies quite often. One that put a lot of effort into protecting it because they're nervous, and others that don't really care because they're going to move really fast, right? And I guess it's a feedback mechanism for which one works for you. And obviously, you got to pick the one. If you're not going to move fast, and you got competitors stealing it and using it against you, that was a bad choice. But I have heard companies say couldn't care less.
Wow. And these are these IP companies, or are these semis that are doing design?
System houses that do. I won't mention the ones,
right,
but they're system houses that do semiconductors.
Okay.
For their business.
Interesting.
Yep. And big ones.
Okay. Okay. Thanks for the question, John. More questions from the audience? Okay. Well, I've got some questions.
No, we have...
there was a question over there.
Okay.
Okay, thanks. Brandy Torrance from ChipWorks. I was wondering what kind of due diligence do companies do to try to understand whether there's any legal issues with their IP they're buying? I mean, Alan, IDT, what does it do in buying the IP blocks? And then also GlobalFoundries, do they do anything, or given that they're actually fabricating the IP, do they do any due diligence at all into the IP that's going on the chips?
Okay, I'll start and then I'll pass it on if you don't mind.
Fine.
So a lot of the risk or the assessment of the effort depends really on the company you're dealing with. Because if you're dealing with a company that has a reputation they need to protect, that's a built-in freebie, right? You're going to ride off their need to be a reputable company. And if you're dealing with a company that has not much to lose but a lot to gain, so in other words, an emerging company, or it can be an emerging country or not, obviously they have a lot to lose, but they have more to gain than lose, if you will, because they don't have much already on the table. So they may behave unethically or just unknowingly not care as much, and then you carry that risk or go for the ride with them. So I think it depends, and you got to assess where they sit in this, what risk they take on. The more they take on, the less you have to worry about it. So you definitely go for some legal stuff in the contracts, indemnification, things like this. But I never bank on it. I just put it in there to say, hey, I'm not stupid, I'm thinking of this stuff. You also have architects and engineers looking at it, and they have their opinion. Like they have an opinion about how new this is, have they seen it before and stuff. So it's not perfect, and it's not the same model for everybody, but so far it's worked.
So from the other part of the question, what are we doing as GlobalFoundries? What I see is happening is in the contract negotiation when we talk to to our customers, we regularly ask those questions: where's your cells coming from? Where's your I/O coming from? Where's your memory coming from? This is a standard type check because it has implications to the business deal already, and so that's typically known. But I'm not aware of any complex things which may be in the systematic of the product, which we may not know. So we don't regularly drill down deeply into the customer's system to see if there is anything. But the standard things, yes. But the real complex things, we rely on our customers to take care of that.
Kind of a quick follow-up maybe. So have either of you ever pulled the plug on a deal because you've been worried that that the IP wasn't owned by the people trying to sell it to you?
Well, I don't have the overview, but I'm not aware of any.
I think so. Yeah. Yeah. I'm trying to remember what, it wasn't at the company I'm at now, but yeah, it has occurred.
So I have a follow-up question to that one. In the semiconductor companies, you know, you see the tier ones will put out a chip, and then there'll be secondary markets where fast followers will rise up in China and India to put out the same kind of functionality of a chip. Do you see this fast follower in the IP industry to where you get that second wave of low-cost providers that are part of your trusted IP ecosystem? Probably start with GlobalFoundries there, Gerd, if you don't mind.
Well, we are building this trusted base. So I think once we have that, it's I think that's a good foundation to work from. And we have a qualification program in place where we qualify vendors, and I think we have proper checks in place to make sure that the IP is owned and their own. And so we look at that, and is it really their own? I mean, you don't look into the last detail of the transistor or the design. But I mean, we have significant talks about that, and so that we have the impression we wouldn't go ahead with a deal which is somehow fishy or so. I cannot imagine we would do that. It would jeopardize our not only that business but the whole entire reputation. So I think so. Yes, there are for these IP deals. There's through the routine of qualifying them, there is significant checks in place. Sufficient checks in place.
And yes, I do see that there'll be fast followers, and they tend to, like the smaller companies in general, tend to try to sell their IP cheaper. They're trying to get their foot in the door, right? They'll try to be agile, but you take on the risk of the quality and the risk of the timeliness. So I haven't noticed any pattern of infringement or any risk like that. I don't think many companies build their model on that. They just may stumble into it, and some companies put more attention into it, more care, and it comes for free when the company has more reputation on the line. It comes for cheaper.
And also, you know, in these emerging market countries, business is still done on a lot more personal level, and it depends a lot more on relationships. So, you know, to the extent that you can get to know your group that you're dealing with, you'll have much better results.
So, Alan, your answer to the last two questions seemed to indicate that you thought that IP theft may happen on an institutional level. That that basically you're saying, you know, your trust in the end customer is basically leading you to say, okay, well, this customer is trustworthy and this customer isn't. But how do you address like the you know, one has to assume that it may also happen on an individual level, and how would you address, you know, an individual perpetrating the theft of the IP rather than it happening on an institutional level?
Right, okay. So I don't think it happens a hell of a lot, just to back up here, right? I just think you know, so I don't want to make it, but it's pretty hard, right? If you have individuals, and we're all individuals, and like Jonathan says, these things happen unknowingly also, right? So it's pretty hard, and it becomes practically or mechanically difficult when it starts to become farther down. So I have, as this gentleman up front asked, ended a deal based on that worry or that actual proof. But you know, I don't see it as something I'm dealing with all the time. Like I deal with quality and risk all the time. So risk from a timeline, an execution, a quality, a specmanship, that's a daily or like an engagement model issue all the time. This thing is something you pay attention to, you do your homework, keep your head about you, and hopefully you get through it fine.
Well, the thing is, customers don't buy, our customers, so the IC companies don't buy IP by the pound. So they make very careful choices, and they really select their IP vendors very carefully. And they think a lot about it because the risk is just too high. Right. I mean, especially the schedule risk for number one, the quality risk. If you buy a piece of IP and it doesn't work and you find it out, you're in for another spin or maybe 2 spins, and the sweet spot of the market has moved. So so it's just too risky to buy non-trustworthy IP. And this in this context. They all look about making sure they buy legal and valid IP. So as much as they can know. So because the risk is just enormous.
So Gerd, as GlobalFoundries builds up your ecosystem of IP providers, are you seeing a lot of IP development happening in these emerging markets? And Alan, are you guys actually sourcing IP from companies that are based on and doing all the development in those emerging markets as well?
Well, go ahead.
So, so we pick up IP all over the place. We pick up complicated IP, jelly bean IP, right? So I can't think of a list in my head here, but a lot of the times, the IP has a component or contributing members in North America and use a good chunk of the development in another country like India or China. So can I think of where it's, I think I could probably think of when it's just China, for instance, or just India.
Yeah, I'm thinking of where the actual company and therefore maybe even the legal transaction is consummated in one of these emerging markets, right? And if that's practically happening and if there are any legal issues to it, or if it's really just outsourcing of engineering resources by, say, a Europe or North American-based company where sort of that aspect of the emerging region is sort of hidden behind the cloak of, their otherwise, brand and persona and everything else.
Yeah. So I can't pick it out of my head for sure. So I don't want to say, yeah, absolutely. But I feel like, because a lot of IP deals go on and stuff like that, and I come in sometimes at the end and stuff like that. So
we have customers with big teams in, especially India.
Yeah.
And these teams are driven like an offspring center of their own. And so they do certain pieces of the design, but they own those centers. So in this sense, I've never seen of IP issues in the sense other than really on individual cases that people may just go away with ideas or so, but it's not in an institutionalized type thing.
But it does seem that that's inevitable, what Adam is describing, that,
yes,
given the arc of these countries' development, and it's going to happen certainly within the next 10 years. You're going to see that happening. And I think it's interesting to also look at it historically. That if you think about where these countries have come in the last 20 or 30 years, I mean, it's really incredible. I mean, you think about that. That China literally just opened up in about 1980. And it passed all its IP laws since 1980. And China, and prior to that, they have basically thousands of years of tradition of not having IP rights. Right. So they've really come a long way very fast when you consider that. And even India, I mean, they've had laws on the books for a long time because they were a colony, but they haven't really opened up in any meaningful way in terms of trade until around 1990.
Can I ask a question here?
Please.
Did you have any cases, or how good are the chances you see to win a case, an IP case in China, for instance?
Well, it's getting better. It's getting much better. I would say the trend is definitely good.
Okay.
And there aren't that many patent cases, but generally the courts are taking them seriously, and they write real opinions, and they really analyze it. And the law is coming to life there. It has some meaning for them. You've seen, there is some case law starting in India dealing with software copyright. Microsoft has recently had some favorable decisions there. So, so they are moving in the right direction for sure.
Mm-hmm.
Yeah.
Okay.
Okay. So we have more questions from the audience.
For Jonathan, I was wondering if you could elaborate a little on your previous statement about the foundry's liability for manufacturing stolen IP. I'm not a lawyer, but it sounded to me kind of like holding the phone company liable for a harassing phone call or FedEx liable for shipping drugs. I was wondering if you could just elaborate a little on what the foundries really are liable for in the case of stolen IP.
Well, I mean, certainly in the case of patent rights, there's really nothing you can do because there's no component. I mean, there's no necessary component of knowing that you're infringing the works. In terms of other rights, well, I mean, in terms of trade secrets, to some extent, you have to wonder whether there really are secrets because these chips are being manufactured and distributed, and we all know about firms that specialize in reverse engineering the chip designs anyway. Basically, there, if there was actual improper behavior by a customer of a foundry, that customer can be liable, and the foundry, depending upon the, it really all depends on the contractual relationship. They can have responsibility as well.
I think we should go with a fair amount of common sense here. So if we know as a foundry, we have to act. So we cannot go ahead. So the question is, do we need to be the CIA or drilling down in the customer designs? No, I don't think we have to do that. So I think we have to be reasonably vigilant so that we are doing the right thing, and then I trust the lawyers will save us when we have a case.
I mean, I think by and large the foundries would want to, and quite rightly, want to push the responsibility onto their customer because they're just a carrier of the design.
Right.
So it would be hard to see why a customer would refuse it, other than if they're not doing something properly. They know they're acting improperly. So
right.
But on the other hand, there still remains the fact that, particularly if you have small customers, how much does that warranty and indemnification really mean?
Right.
I think that's where the problem really is.
Yeah, as you said, whoever was infringed upon is going to go after whoever has the biggest pockets, right? So that
Right.
could very well be the foundry in the case of a small customer.
Right. Exactly.
And our customers, again, not at this company, I'm sure it happens, but I've seen it at my previous company, demand indemnification to the point where we have ended deals ourselves,
Sure.
just simply because the deal wasn't worth the hassle,
Right.
even though we didn't intend to infringe.
Right.
And another example at that previous company, and it just jogged my memory, we actually did infringe. We had picked up IP, it did infringe, and we ended up having to settle out of court, of course, and pay margins. Royalties.
Actually, there is the reverse case as well. So I know that our customers are being harassed by patent trolls, patent trolls coming along saying, you're infringing this, and then you have to make a big case about trying to find out if you really did. And so it's a hazard for the big companies. They have a small legal army to kind of wave them off, because there's one case a day or so coming in big companies. So
and IDT just recently, a few months ago, was the pursuer in that activity. So we pursued a company infringing on our IP.
Interesting.
Yep, and we were serious about it.
That was probably a good case. So, but
yep.
the
Oh yeah, no, they
are the destructive cases. Actually.
Yeah, no, it was a good case, and they stopped.
Yeah.
We spent coin to get there, but we got there and worked out a deal.
Good example. Good example. question up here in the front.
I have one question for Jonathan. Okay. So when we negotiate with the China companies, we're always struggling with the legal terms. So sometimes you have to make trade-offs. So the question is, which one you recommend to insist more, request more, mean the governing law or the arbitration side? If I have to choose one to, insist.
Did you have a choice there? You said arbitration and something else?
Governing law.
Governing law.
Governing law. Oh,
Yeah,
okay.
governing law or arbitration.
Okay. Well, I mean, I think you're focusing on the right area, which is, what you call dispute resolution, and whether you want to rely on the court system or whether you want to use arbitration. If you're going to go if you're going to go with arbitration, then your choice of law provision can be less significant. But in general, as I said, I think that you want to arbitration does seem like a good route these days.
Well, I think you mentioned it earlier that arbitration is more friendly to foreign companies. Is that accurate?
Yes.
As opposed to the following the law, it may be interpreted by the various judges up through the chain, right?
Yes, that's right.
My impression is the legal system is encouraging arbitration to a big deal. So I see it happening in many legal systems actually, that they rather than pounding on the table and this is law.
Is it the legal systems that are encouraging it, or is it the companies that are engaging in the contracts in order to mitigate costs ultimately and simplify the process if there are issues in infringement?
Well, it's a lot. I mean, there's definitely the cost factor. There's also the just picking neutral ground.
Yeah.
If you're separated half a world apart.
Right.
What do you do? Where do you have your dispute?
Sure.
So there are natural reasons why it would be in place.
Right. All right, everyone. So we're just about out of time today. A big thank you to Ron Moore, who's been walking around with a microphone. He's from ARM. He was also the organizer for the panel. Thank you, Ron. And thank you to our panelists today and to the audience as well for all your participation. We hope you enjoyed the panel. Have a great rest of the show. Thank you.
Okay.